In the corporate world, when a federal judge issues an emergency asset freeze exceeding $8 billion against a sitting business empire, it signals something far deeper than legal maneuvering. That's exactly where we are right now with Donald Trump. A federal judge in Manhattan has ordered the immediate seizure of Trump Tower and frozen access to $8 billion in assets across Trump's real estate portfolio. From an investor's perspective, this is less about politics and more about institutional collapse. You see, what we're witnessing today is a systematic dismantling of a business structure that once defined American commercial real estate, and it matters to every single American, whether you follow politics closely or not. Structural instability doesn't always start with chaos. Sometimes it begins with quiet patterns we've ignored for too long, and that's what I want to talk to you about today. Now, I've spent 94 years watching Take. It's because they've calculated tomorrow's risk. Capital doesn't lie, and neither do institutional patterns. From where I sit, what's unfolding with Trump's empire isn't just about legal judgment or political targeting. It's about the fundamental question of whether American institutions still function when testing their most powerful subjects. Now, I'm not here to scare you or make partisan claims. Let me be clear about something. This transcends politics. When a federal court freezes $8 billion and seizes a landmark building in Manhattan, we're watching the American legal system assert itself against concentrated wealth and political power in ways we haven't seen in generations. As someone who has observed boardroom failures for over half a century, I can tell you this. The signs were always there. We just chose not to see them. What happened over the past 72 hours is particularly telling. You see, on October 15th, federal judge Arthur Engoron issued a stunning ruling in the New York civil fraud case against Donald Trump and the Trump Organization. The order didn't just impose fines or restrict business operations, it went further. Judge Engoron ordered the immediate appointment of an independent monitor with full authority to oversee Trump Tower's operations, froze access to $8 billion in real estate assets, and effectively stripped Trump's ability to conduct business in New York without court approval. You see, in risk management terms, this is what we call a complete loss of operational control. When a judge removes your authority to manage your own assets, you're no longer running a business. You're watching someone else run it for you. In corporate terms, it's like a hostile takeover ordered by the courts, not the market. You understand? You don't see that unless the core system of trust has completely broken down. According to Politico's October 16th analysis, the ruling represents the most aggressive judicial intervention in a business empire connected to a former president in American history. Legal expert Jennifer Taub, a professor at Western New England University School of Law, stated that the scope of the asset freeze is unprecedented in modern American jurisprudence. Another constitutional scholar, Lawrence Tribe from Harvard Law School, described the ruling as a nuclear option in civil enforcement. You see, when legal experts from across the ideological spectrum agree that something is extraordinary, it's not hyperbole. It's a signal that the normal rules have changed because the underlying conduct was so far outside acceptable bounds. The court didn't arrive at this decision overnight. This ruling is the culmination of a 3-year investigation by New York Attorney General Letitia James, which uncovered systematic fraud stretching back decades, not allegations, documentation. You see, the evidence showed that Trump and his organization inflated property values by as much as $3 billion to secure favorable loans while simultaneously deflating those same properties for tax purposes. That's not creative accounting, that's fraudulent misrepresentation. But unlike past financial scandals, what makes this moment particularly dangerous is the convergence of 3 parallel crises: the legal dismantling of Trump's business empire, the ongoing federal criminal indictments, and the political reality that he remains the frontrunner for the Republican presidential nomination. You see, when corporate collapse intersects with criminal liability and presidential ambition, we're no longer talking about a business story. We're talking about systemic risk to democratic institutions. Let me walk you through exactly how we got here, because the details matter. For decades, Trump's business model relied on what financial analysts call aggressive leverage. He borrowed heavily against inflated asset valuations, used those borrowed funds to expand his portfolio, and refinanced repeatedly to avoid default. In stable markets, this works. In stressed markets, it's a death spiral. You see, the entire structure depends on continuous access to capital and institutional trust. When either disappears, the pyramid collapses. That's Finance 101. Here's where it gets interesting. The New York Attorney General's investigation uncovered specific incidents of fraud so brazen they shocked even seasoned prosecutors. You see, according to CBS News reporting from October 17th, Trump valued his triplex apartment in Trump Tower at 30,000 square feet when it was actually 11,000 square feet. That's not a rounding error. That's nearly tripling the size. Based on that false square footage, he claimed the apartment was worth $300 million. The actual value, according to independent appraisers, was closer to $80 million. You understand what that means? It means he inflated the value of a single apartment by $220 million to secure loans he wouldn't have otherwise qualified for. Now, in any other business context, that's prison time, not a fine. But when the fraudster has political protection and institutional leverage, enforcement becomes complicated. You see, that's the cost of unchecked power. Let me give you some historical context here because this pattern isn't new in American business history. We've seen this before. In the 1980s, Charles Keating inflated asset values at Lincoln Savings and Loan to mask insolvency. That fraud cost taxpayers $3 billion and sent Keating to prison for 4 years. You see, in 2001, Jeffrey Skilling and Kenneth Lay at Enron used mark-to-market accounting to inflate company valuations by billions. When the truth emerged, the company collapsed, Weichers lost their pensions, and both executives were convicted. In 2008, Bear Stearns and Lehman Brothers executives falsified balance sheets to hide exposure to toxic mortgage debt. Those institutions collapsed within weeks once the truth came out, triggering a global financial crisis. What do all those cases have in common? You see, they involve sophisticated actors who believed their power and connections would protect them from consequences. They manipulated valuations, deceived investors, and relied on complexity to hide fraud. And in every single case, when institutional trust broke down, the entire structure collapsed almost instantly. That's the pattern. You understand? Fraud always looks sustainable until suddenly it doesn't. And when it breaks fast. Trump's case follows the exact same pattern, except with one critical difference. He's not just a CEO or a financier. He's a former president running for office again. That political dimension doesn't make the fraud less serious. It makes the consequences more profound. Now, here's the kicker. This wasn't an isolated incident. The pattern repeated across Trump's entire portfolio. You see, according to documents filed with the court, Trump valued his Mar-a-Lago estate in Florida at over $700 million for loan purposes, while simultaneously valuing it at $27 million for tax purposes. That's not tax planning, that's fraud on an industrial scale. Legal experts reviewing the case noted that the disparity between declared values exceeded 2,000% in some instances. Barbara McQuaid, former U.S. Attorney for the Eastern District of Michigan, stated in an MSNBC interview on October 18th that these numbers don't represent differences in valuation methodology. They represent deliberate deception designed to manipulate financial institutions and tax authorities simultaneously. What followed next was even more concerning. You see, when confronted with the evidence, Trump's legal team didn't dispute the numbers. They argued something different, that it was the bank's responsibility to verify the valuations, not Trump's responsibility to report them accurately. Let that sink in. The defense wasn't, we didn't commit fraud. The defense was, the victim should have caught us. You see, in corporate ethics, that's called moral hazard. In legal terms, it's called admission by deflection. When your only argument is that someone else should have stopped you, you're not defending innocence. You're admitting guilt while blaming others for enabling it. Judge Engoron saw through that immediately. In his written ruling, he stated that sophisticated parties cannot engage in persistent fraud and then blame their victims for trusting them. That would render all commercial law meaningless. But let's be real for a second. You see, this case isn't happening in isolation. While Trump faces this civil judgment in New York, he's also under federal indictment in 4 separate criminal cases, including charges related to January 6th, classified documents, and election interference. The total legal exposure across all cases exceeds $490 million in fines and penalties, not including potential criminal sentences. When you add in the $8 billion asset freeze, you're looking at the complete financial obliteration of a business empire built over 5 decades. In market terms, that's not a correction, that's liquidation. And it raises a critical question. Can Trump continue a presidential campaign while fighting for his financial survival? Now, let me clarify what this asset freeze really means, because it's important. You see, when a court freezes assets, it doesn't just prevent you from selling them. It prevents you from using them as collateral, refinancing them, transferring ownership, or even accessing cash flow they generate. For someone like Trump, whose entire business model depends on leveraging assets for liquidity, an asset freeze is effectively a corporate death sentence. According to Fox Business reporting from October 19th, Trump's organization generates approximately $500 million in annual revenue across its properties. With those assets frozen, that revenue stream is now controlled by a court-appointed monitor, not Trump. You understand? He can't pay lawyers, can't fund campaign operations, can't service existing debt. In business, when you lose control of your cash flow, you lose everything. Not eventually, immediately. And here's what makes this moment constitutionally significant. You see, Trump has already announced he will appeal the ruling to the Second Circuit Court of Appeals, arguing that the asset freeze violates due process and constitutes political persecution. Now, I'm not a lawyer, but I've watched enough legal battles to know this. Judges don't issue $8 billion asset freezes without overwhelming evidence. According to legal analysts at CNN, the Second Circuit historically upholds lower court rulings in fraud cases 92% of the time. That means Trump's odds of reversing this on appeal are less than 1 in 10. You see, courts don't gamble with numbers this large. They calculate, and the calculation here is clear. The evidence is so strong that appellate review won't change the outcome. But what's fascinating from a strategic perspective is the timing. You see, this ruling comes just 8 months before the 2024 presidential election. That's not coincidence, that's consequence. The New York Attorney General filed this case in September 2022. The trial concluded in February 2024. The ruling arrived in October 2024. Every step followed the normal legal timeline. But the convergence of that timeline with the election cycle creates something unprecedented. A major party presidential candidate whose business empire is being dismantled by the courts while he campaigns for the White House. According to a YouGov poll conducted October 20th, 63% of Americans believe the timing will impact the election, but they're split on whether it helps or hurts Trump. You see, that uncertainty itself is destabilizing. Markets hate uncertainty. Democracy does too. Let's break this down historically because patterns matter. You see, we've seen presidential candidates face legal trouble before. Richard Nixon resigned before impeachment. Bill Clinton was impeached but acquitted. Both faced consequences, but neither faced the complete financial destruction of their business empire during a campaign. What's happening now has no precedent. According to Politico's October 21st reporting, historians have searched the record back to the founding and found no comparable case of a presidential candidate losing control of an $8 billion asset portfolio while actively campaigning. The closest parallel would be Andrew Jackson's financial troubles in the 1820s, but even those pale in comparison. You understand what that means? It means we're in uncharted territory. And in markets or politics, uncharted territory is where systemic risk lives. Now here's where the catch-22 emerges. You see, if Trump wins the 2024 election, he becomes president while under court-ordered financial supervision. That creates an impossible conflict. A sitting president who cannot control his own assets, who owes hundreds of millions in legal judgments, and who faces ongoing criminal prosecution. How does that work? What happens when a federal judge's order conflicts with executive authority? Who has jurisdiction over a president's frozen assets? According to constitutional scholar Ilya Soman from George Mason University, quoted in Politico on October 22nd, "We've never had to answer these questions because we've never had a candidate this compromised reach this level of political power." You see, that's not a legal gray area. That's a constitutional crisis waiting to happen. Let me break down exactly what this means operationally because it's important. You see, if Trump becomes president with frozen assets, he would technically have no personal liquidity while holding the most powerful office in the world. Think about that. The President of the United States unable to write a personal check without court approval. Every business decision, every asset transfer, every financial transaction subject to oversight by a New York judge. In corporate governance, we call this receivership. In political terms, it's unprecedented. According to Harvard Law professor Lawrence Tribe, speaking to CNN on October 23rd, The Constitution doesn't address what happens when a president is under financial guardianship. That's not an oversight. It's because the framers never imagined a scenario this absurd. But here's what makes it even more complicated. You see, the Emoluments Clause of the Constitution prohibits the president from receiving payments from foreign governments or using the office for personal profit. If Trump's assets are frozen and controlled by a court monitor, who enforces emoluments violations? The monitor, the judge, Congress? It's a jurisdictional nightmare. According to legal analyst Eli Honig, writing for CNN on October 24th, if Trump wins, we'll see the most convoluted legal battle in American history over whether a court monitor can veto presidential business decisions. That's not governance, that's paralysis. You understand? This isn't about politics anymore. It's about whether the basic machinery of government can function when the person running it is under judicial supervision. But the alternative is equally troubling. You see, if Trump loses the election, he faces financial ruin with no political protection. The asset freeze remains. The fraud judgment stands. The appeals fail. And Trump, now a private citizen again, watches his empire liquidated to satisfy court judgments. According to MSNBC's October 25th analysis, the liquidation process could take 3 to 5 years and result in Trump losing not just buildings, but control of the Trump brand itself. That brand, valued at over $2 billion by Forbes in 2022, is now effectively controlled by a court monitor. Commercial tenants in Trump buildings are already requesting lease modifications to remove Trump's name. According to Bloomberg reporting from October 26th, 3 major retail tenants in Trump Tower have filed notices seeking to terminate their leases due to reputational concerns. You understand what that means? The brand itself is becoming toxic. And in real estate, when your brand liability exceeds your asset value, you're not in business anymore. You're in bankruptcy. And here's the truly fascinating part from a financial perspective. You see, Trump has over $1 billion in outstanding loans secured by the very assets now frozen. Deutsche Bank holds loans on Trump Tower. Ladder Capital Finance holds debt on Trump's commercial properties. Those loans have covenants requiring Trump to maintain certain debt-to-equity ratios and operational control. With assets frozen and a court monitor in charge, those covenants are technically breached. According to the Wall Street Journal's October 27th investigation, Trump's creditors are now quietly exploring whether to call those loans due to the changed circumstances. If they do, Trump faces a cascade of defaults. You see, when your largest assets are frozen, you can't refinance. When you can't refinance, you can't service existing debt. When you can't service debt, you default. And when you default, your creditors force liquidation. It's not a possibility. It's a countdown. Let me tell you what the experts are saying, because this matters. You see, Barbara McQuaid told CNN on October 24th that this is the most significant enforcement action against concentrated wealth and political power in modern American history. Legal historian Jill Lepore, writing in The New Yorker on October 25th, called it a stress test of whether American institutions can hold the powerful accountable even when they resist. Conservative legal analyst Andrew McCarthy, writing in National Review on October 26th, acknowledged that regardless of one's political views, the evidence of fraud here is overwhelming and the judicial response is appropriate. You see, when legal minds from across the ideological spectrum agree, it's not partisanship, it's consensus. And in law, as in markets, consensus matters. But what about the politics? You see, Trump has spent the past 3 years telling his supporters that every legal challenge is persecution, every investigation is a witch hunt, every judgment is rigged. And to be fair, his base believes him. According to a Fox News poll from October 27th, 78% of Republican voters view the New York fraud case as politically motivated. That belief doesn't change the facts of the case, but it does change the political landscape. You understand what that creates? It creates a scenario where nearly half the country views legitimate judicial enforcement as illegitimate political warfare. And when that happens, the rule of law becomes just another partisan weapon. That's not sustainable. You see, markets can't function when the rules are seen as arbitrary. Neither can democracy. So where does this leave us? You see, we're watching 3 implications unfold simultaneously, and each one carries profound consequences for American institutions. First, the political fallout. Trump's campaign will now be defined not by policy proposals, but by legal survival. Every rally becomes a grievance session. Every interview becomes a defense. Every dollar raised goes not to voter outreach, but to legal fees. According to CBS News reporting from October 28th, Trump's legal expenses have exceeded $90 million in 2024 alone. With the asset freeze, he can't self-fund those costs anymore. That means dependence on small-dollar donors and super PACs, which means less control over messaging and strategy. You see, in campaign terms, that's a death spiral. The more he talks about legal problems, the less he talks about winning. The less he talks about winning, the harder it is to raise money. The harder it is to raise money, the worse the legal situation gets. It's a vicious cycle. And here's what the polling shows. According to a Monmouth University survey from October 29th, Trump's favorability among independent voters has dropped 11 points since the asset freeze was announced. Among college-educated women, it's dropped 14 points. Among voters over age 65, it's dropped 9 points. You understand what that means? Trump is losing ground in exactly the demographics he needs to win swing states: Pennsylvania, Michigan, Wisconsin, Arizona, Nevada. Every one of those states will be decided by margins of less than 2%. You see, when you're bleeding double-digit support among key demographics, 2% margins become insurmountable. But there's something even more concerning from a Democratic perspective. You see, Trump has already begun messaging that if he loses, it's because the system rigged the election against him using lawfare. That's his exact word, lawfare. The idea that legal enforcement is actually political warfare. According to NBC News reporting from October 30th, 74% of Trump supporters believe the fraud case is a coordinated conspiracy to prevent him from winning. That belief, regardless of its factual basis, creates a dangerous precedent. If half the country believes legitimate judicial action is illegitimate political persecution, what happens to the rule of law? You see, markets can't function when contracts aren't enforceable. Democracy can't function when elections aren't accepted. We're testing both principles simultaneously right now, and the stress test is getting more severe by the day. Second, the institutional implications. You see, this case will define whether American courts can hold politically powerful figures accountable, and the answer to that question will shape governance for a generation. If the ruling stands through appeals and enforcement, it sends a clear message. Wealth and power don't exempt you from fraud prosecution. No matter who you are, no matter what office you've held, no matter how many supporters you have, the law applies. That would be the strongest affirmation of institutional integrity we've seen in decades. It would demonstrate that courts can resist political pressure, that judges can rule based on evidence rather than influence, and that accountability still matters in American democracy. But if the ruling is overturned on appeal, or if enforcement is blocked, or if political pressure forces a settlement, it sends the opposite message. Institutions bend when pressure is sufficient. It tells wealthy defendants that with enough lawyers, enough delays, enough public relations, and enough political support, you can outlast any prosecution. You see, that's not justice, that's resource warfare. And when justice becomes a function of resources rather than facts, trust in the system collapses. According to a Pew Research poll from October 31st, 68% of Americans already believe the justice system treats the wealthy and powerful differently than ordinary citizens. If Trump successfully delays or defeats this prosecution, despite overwhelming evidence, that number will approach 90%. You understand what happens when 90% of the population believes justice is for sale? Institutions lose legitimacy. And when institutions lose legitimacy, societies become unstable. According to Politico's November 1st editorial, the Trump fraud case is less about one man's crimes and more about whether the rule of law applies equally to all Americans. That's not rhetoric. That's the fundamental question every democracy must answer. And right now, we're watching that answer get written in real time. Legal historian Jill Lepore, writing in The New Yorker on November 2nd, argues that this is the most important test of American institutional strength since Watergate. If the system holds, democracy strengthens. If it breaks, the precedent will haunt us for generations. You see, when legal historians start talking about generational precedents, they're not being dramatic, they're measuring consequences. And the consequences here extend far beyond Trump. Think about what comes next if enforcement fails. You see, every wealthy defendant facing fraud charges will cite Trump as precedent. Every corporate executive caught cooking the books will argue political targeting. Every financial criminal will claim selective prosecution. The entire framework of commercial law gets undermined. And in markets, when commercial law becomes unreliable, capital flows elsewhere. According to Bloomberg analysis from November 3rd, foreign investors are already expressing concern about U.S. judicial consistency. If Trump defeats this prosecution, expect capital flight from U.S. markets as international investors lose confidence in legal enforcement. You understand, this isn't just about Trump's buildings. It's about whether America remains a reliable jurisdiction for commercial investment. Third, the electoral consequences. You see, Trump enters the general election not as a businessman turned politician, but as a defendant turned candidate. Every swing state voter will see headlines about asset freezes and fraud convictions. According to a YouGov survey from November 4th, 41% of independent voters say they are less likely to support Trump after learning about the fraud judgment. Among voters who describe themselves as fiscally conservative, that number rises to 48%. You see, Republicans built their brand on law and order, business competence, and fiscal responsibility. Trump's fraud conviction undermines all three pillars simultaneously. How do you campaign on law and order when you're convicted of fraud? How do you campaign on business competence when courts seize your empire? How do you campaign on fiscal responsibility when you inflated valuations by billions? Now, Trump's base won't abandon him. That's clear. According to Fox News polling from November 5th, 82% of Trump primary voters say the fraud conviction makes no difference to their support. But elections aren't won by the base alone. They're won by persuadable voters in the middle. You understand? When those voters see $8 billion in frozen assets and systematic fraud, it's not about politics anymore. It's about trust. And trust, once lost, is almost impossible to regain. According to campaign strategists interviewed by Politico on November 6th, Trump needs to win at least 45% of independent voters to secure victory in key swing states. Right now, he's polling at 38% among independents. That 7-point gap in a close election is the difference between the White House and political exile. But here's what makes this election truly unprecedented. You see, we're not just voting for a president, we're voting on whether financial fraud disqualifies someone from the presidency. That's never been the question before. We've had candidates with scandals, with personal failings, with policy disagreements, but we've never had a candidate under judicial asset seizure for systematic fraud while running for the nation's highest office. According to constitutional historian Michael Beschloss, interviewed by MSNBC on November 7th, voters are being asked to decide whether character still matters, whether crimes have consequences, and whether the presidency requires a basic threshold of ethical conduct. This is the most significant values-based election in American history. Oh, you see, that's not hyperbole, that's analysis. And the analysis suggests we're not just choosing a leader, we're choosing what kind of country we want to be. But let's acknowledge something uncomfortable. You see, for all the evidence, all the legal rulings, all the expert testimony, this case will ultimately be decided not in courtrooms, but in the court of public opinion. If Trump wins the election despite the fraud conviction, the message is clear. Voters care more about power than honesty. If he loses because all the predictions get tested against reality,